This lawsuit potentially is going to have direct implications across the nation in how you are able to exercise your Second Amendment rights. Now, before we begin, this video is sponsored by USCCA, and they are doing a special contest right now. You can find out more information in the description below this video. But the contest does end soon, and they are giving away something special. I definitely encourage you to participate. I'll give you a hint. It can fit in your holster. Now, in today's video, we're going to be talking about a brand new lawsuit that just recently got filed in district court down in San Diego called Richards v. Bonta. And it's seeking a motion for declaratory relief that California's mandatory 10-day waiting period is unconstitutional under a Bruin analysis. Now, a little bit of a background on how the California system works. Many states have what is referred to as a NICS system. So if you go to a gun dealer and you attempt to acquire a firearm, you fill out a 4473 form, that's the federal document. And then the person behind the counter, they go on to a computer-driven system called the NICS system. This is an interface with the federal government where they put in your information and they wait to hear back, usually within about 5 minutes, as to whether or not you are a prohibited person. If it turns out you're not, then you get to walk out of the store with your gun. This seems entirely reasonable. California, along with a few other states, have a different system in place. In California, the gun dealer does not interface directly with the federal government. They interface with the California Department of Justice. California Department of Justice goes through their own database to see whether or not the applicant is prohibited in California. Assuming that they're not, then they will contact the NICS system to see whether or not they potentially are either federally prohibited or prohibited in any other state. There is also a mandatory 10-day waiting period. Now, this has been around for quite some time. It was originally legislatively enacted so that if someone was looking to acquire a firearm for the purposes of engaging in illegal conduct, they would have 10 days to think about it, to cool off, okay? It was intended to protect individuals from other individuals that might be engaged in a crime of passion. In fact, it was originally entitled the Cooling Off Law. This was challenged a number of years ago in a case called Silvestri. And the challenge made absolutely logical sense. They effectively said, well, if the legislative purpose is to create a cooling off period for someone who does not own a gun, there may be a rational relationship with that. Now, a little sidebar for a second. The Silvestri case was litigated way before Bruin ever came into fruition. So back then, the plaintiffs said, if an individual doesn't own a gun, then perhaps we would be willing to concede that a 10-day waiting period might have some merit. But for someone who already owns a gun, this makes absolutely no logical sense. I mean, you could theoretically have an individual that has a concealed weapons permit wearing a gun into a store to go purchase another firearm, and the state is mandating that they wait 10 days to cool off before acquiring that firearm. Well, if the individual is prepared to engage in illegal conduct, this doesn't make any logical sense. They've already got a gun. They could do so right now. Well, the district judge in that original case agreed with the argument. It was ultimately overturned by the Ninth Circuit Court of Appeals, and their argument, as laughable as it sounds, was that the 10-day waiting period made logical sense because an individual, while they may actually possess other arms already, they may want to engage in criminal conduct with this specific firearm. And the 10-day waiting period had a rational basis. Well, like I said, this was all done before Bruin. This new lawsuit in Richards, this basically says, look, under a Bruin analysis, there is no argument that the state could muster that a 10-day waiting period is consistent with the history of firearms regulations at the time of the ratification. This makes absolutely no logical sense. Now, what's interesting is that this lawsuit is being filed in San Diego with a judge that is putatively fairly aligned with Second Amendment rights. So we'll have to see it. Like I said, it just recently got filed. It's just beginning its process. What I'm curious to see, and we don't know yet, is whether or not the plaintiffs are going to file a motion for a preliminary injunction. I think that's probably going to be the strategy, but we'll have to see. Like I said, it's brand new. Definitely encourage you to look at the case. The original complaint, which is available online by simply Googling Richards v. Bonta, is exceptionally well written. And I think the arguments are laid out quite nicely there. As always, if you guys need to contact me for any reason whatsoever, please feel free to do so. My email address is steven@artemishq.com. And as always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.
It's a true story of self-defense. We interviewed an armed Lyft driver who was carjacked to help answer these questions. Should I carry a gun while driving? And what does a carjacking actually look like? Just click the video next to me to watch this must-see interview.